Oh, wow. Oh, wow. There's not been any music here this whole time. Oh, I feel so embarrassed. The music's been playing here for me. That's just horrible. I should have been like, what's going on? Why is it so silent? Because we're getting started right now, ladies and gentlemen. The show's on. The show started. I'm just not driving the car correctly, and we're already off track. Already off track. What can I say? Ladies and gentlemen, we're getting started with Judge Boyd this morning. Judge Boyd just had a crazy case, a rapper on trial for murder. That case just fell off the tracks this week when a motion in limine was violated by the defense team. We're going to get to hear all about it. I got news stories. I've got all the backstory and everything right here for you right now this morning. Then after that, we've got not a new case, not a couple. It's actually a year or two old. No, actually, it came from January 4th of 2024 is when I found it actually. But it is a solved sit case that Hutch suggested to me, and I wanted to share it with you guys because it reminds me so much of the Estrada case in front of Webster, and I just think it's interesting to see a solved sit on a pill. And all of it starts right now.
Crime scene photos and a shell casing. That's what was shown to a jury in day 3 of the Tamor McIntyre capital murder trial.
McIntyre, also known by his rap name, Tay K47. He's accused of robbing and killing photographer Mark Saldivar in April of 2017. Much of the testimony today focused on how that investigation began. Erica Hernandez joins us now live in the studio. Erica, what did the jury learn about those key pieces of evidence today?
Yeah, so they learned that while not much, investigators still found significant items at the crime scene. Investigators at first responding officers were called up to talk about what they were able to find when they got to the scene, which was outside the Chick-fil-A across from North Star Mall. Now, right next to Saldivar, one 9mm casing was found, as well as a bag of marijuana. There was even marijuana stuffed inside his mouth, according to testimony. Now, that shell casing, the only one found at the scene. Also, one officer spoke about a business manager coming forward and offering surveillance footage. While it hasn't been shown to the jury, he did describe what it had on it.
From what we could see, you could see a black car enter the parking lot of the Chick-fil-A. It appeared the complainant was on the hood of the car, and then the front passenger exits the vehicle, and he appeared to have a white shirt, and then you see the complainant fall off the hood of the vehicle.
Now, at some point, we do expect that video to be shown to the jury, but it's still unclear if you get a good look at who that shooter is in the video, which so far the prosecution hasn't had a witness be able to identify. Now, most of what was presented today was about the evidence collected and what the crime scene looked like. Tomorrow, we do expect to hear from the medical examiner, and we're still awaiting the testimony from the 3 individuals that were alleged to be in the vehicle with McIntyre.
When we talk about those 3 people, were they ever charged in this case?
So it's really interesting. There was one individual that did take a 30-year plea deal in this case. A female that was alleged to be the driver was first charged with capital murder, then it was lessened to a tampering charge, and then it was completely dismissed. And that third individual, we haven't been able to find any records of a charge that he was facing. So it'll be interesting to see if this is all because they are going to testify. Right. That's why those charges are just not there anymore.
There's some interesting attention on this trial. The defendant is a Texas rapper known as Tay K. He made a rap video while on the run. Has that been talked about yet during this trial?
Interesting enough, it has not been. So in opening arguments, they did mention how he was a rapper and was known, but that video has not been talked about yet. So I know it was really big in pretrial motions that they were going to introduce this. So it'll be really interesting to see when the prosecutors actually do talk about it and if they will show that music video to the jury.
All right, Erica, thank you. By the way, the murder trial of Tay K is expected to continue tomorrow starting at 9 a.m. That's the rough schedule of when we will live stream that hearing on ksat.com as well as KSAT Plus. A big misstep by attorneys representing a local rapper accused of murder. Tamor McIntyre's defense team scolded by the judge today. McIntyre, also known as TK47, is charged in the deadly robbery of photographer Mark Saldivar back in 2017.
As the driver of the alleged getaway car was on the stand, the defense made a mistake. Erica Hernandez joins us live here in the studio to explain all this. So, Erica, what did the defense do wrong here?
Yeah, Myra, before this trial began, a motion was granted that the defense could not bring up any bad acts committed by Mark Saldivar in front of the jury without further discussion outside the jury's presence. Well, today during cross-examination, attorney John Hunter brought up that Saldivar might have had child pornography. Now, this was as Joanna Reyes was being questioned. Reyes says she was the one driving the car the day Saldivar was killed and saw Tamor McIntyre pull the trigger. In cross-examination, the defense was trying to imply that Reyes instigated the entire incident by leading Saldivar on and telling the others in the car that he had child pornography in his bag. That led to a quick objection by the state, the jury being removed from the courtroom, and Judge Stephanie Boyd having some words with the defense.
What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But instead, you have people who are violating rules.
Now, at worst, this could have ended in a mistrial, but Judge Boyd asked the jury to disregard any mention of child pornography during questioning or testimony instead. Now, the defense did continue to grill Reyes, even asking her if she was the one who placed the gun in McIntyre's hand, which she denied. Now, Reyes did finish testifying today. Overall, her testimony seemed to be a benefit for the state as she didn't change her accounts of major details that she claims happened that day. Now, testimony in this trial will resume tomorrow.
Nicole, 2019 CR 12495, State versus Tamor McIntyre. Can I have parties announced for the record?
Yes, Jason Garahan and Megan Galloway for the state, Your Honor.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor. I believe he's still back in holding.
Oh, he's back in holding. All right, we'll wait for him. Getting dressed. Okay.
Your Honor, we're trying to get that child.
All right, no problem.
Okay, never mind.
Okay.
That's what I'll be talking.
All right, and you're Mr. McIntyre?
Yes, ma'am.
All right, so are both parties ready to proceed?
My co-counsel gets back.
Oh, no, I think they're bringing the witness, but you all are ready to proceed with
Yes,
trial
yes, Your Honor.
once. All right. So I'm being told that all of the jurors are here.
Great, thank you, Judge.
And Jenna, I'm going to start inputting this in the system. So once I finish, I'll just put them up here. All right, thank you. Oh, you need a seat? Yes. Is there an extra chair for the attorney?
That back room. Get one for the back room, Judge?
Oh, yes.
Here, I can grab one from my office.
All right, we can take that one, I think.
It's a rolling chair, Judge.
All right. Counsel, you okay with the rolling chair?
Of course. I can grab one from the witness room.
Oh, here's one here.
Oh.
Let me go around.
Okay. Thank you, Norma. Oh, we have one. Thank you.
All the chairs are here, just.
Just give me a moment. So just so everyone is aware. Yes.
Sorry, Your Honor.
When there are cases where I'm assuming, what is your name? All right. So I usually let the jurors know that the person sitting next to them is their attorney. All right. All right. And both parties are ready to proceed?
Yes, Your Honor.
Yes.
Yes, Your Honor.
Okay. All right. Let's bring the jurors in.
All right, for the jury.
Court is calling 2019 CR 12495 State versus Tamar McIntyre. If I can have parties announced for the record.
It's Jason Garahan and Megan Galloway for the state, Your Honor.
John Hunter, Jerry Goldstein, Thomas Lane for Mr. McIntyre, Your Honor. He's
And
present.
are you Mr. McIntyre? Are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, if you could state, if you could have your witness just retake the stand. All right, you're still under oath. And if you could just restate your name for the record, please.
Joanna Reyes.
All right, make sure you keep your voice up so that members of the jury can hear. All right, defense, I believe it's still your witness.
Thank you, Your Honor. All right, Ms. Reyes, when we left off yesterday, I had asked you if you had previously told the detective that you knew that Mark getting into the car had the intention of having sex with you. Do you recall that question?
No,
Okay, well, let me ask you again. When Mark got into your car, you knew that his intention was to have sex with you, right?
no, sir.
But that's not what you told the detective, correct?
No.
You had an opportunity to review your video yesterday after court
Yes, sir.
in its entirety,
Yes.
okay? I'm gonna call your attention to about 50 minutes and 39 seconds into that. Mr. Lane, if you could get that queued up for us.
Toothbrushes are all over. Okay, so everybody had a toothbrush?
The ones that was normal was mine,
What do you mean all one?
like, because they had vibrating toothbrushes, the ones that like.
So the vibrating ones, are they
Theirs.
Okay, all right. I know it's gonna be kind of a stretch for you to remember, but you said that the guy had a roll of condoms.
Yeah.
What
I,
color?
I.
No, I don't think you're.
I didn't look back.
Did you see the roll?
I didn't see it.
Did you see the lube?
I didn't see none of it. They just said it.
So what did they say?
They just said, were you, like, they just said, or were you trying to rape her and this and that? Or maybe I think Tamar showed me the roll of condoms, but that was it. And I don't know if they're black or gold, I can't remember, but he was just like, were you trying to rape her and this and that, and that was it. And that's the only thing.
Let me ask you, do you think the dude had some condoms in his backpack? Sure.
No, he just thought he was in a book. That's just that of course men, some men. That's of course some men, like, I didn't think that far into it, but that, that was just, I didn't even, like I said, I never looked back, I never looked to the side, nothing. I was scared.
So you told the detective that he thought he was gonna fuck, right?
Because he was interpreting that.
I'm asking you that you interpreted him as having interpreted he was planning on having sex with you, correct?
Because he said that.
And you saw that there were in fact condoms in the man's backpack after this was all over,
I
right?
never saw anything that was in the backpack.
You heard the portion where you said that Tamar showed you the condoms, right?
Yes, but I didn't see anything else that was in the backpack.
And the reason why Mark thought that he was gonna have sex with you is because that's what you led him to believe, correct?
Speculation,
She can't testify to what.
There's nothing speculative about what you previously said, Your Honor.
Approach. All right. So, defense, ask your question and then state, if there's an objection to it, you can make your objection. And I'll give the defense a chance to respond to that objection and I will make a ruling. So ask your question, defense.
Mark thought he was going to have sex with you because you had led him to believe that's what was gonna happen that day, right?
No, sir.
Objection. Speculation.
All right. The objection, the witness has already answered. Ask your next question.
Thank you, Judge. Yesterday, to recap, we talked about the fact that Mark had tried to contact you on Instagram some time back before this incident, correct?
Correct,
And he had contacted you, right?
correct,
And that resulted in you blocking him from your Instagram account, right?
correct.
Because his account was largely pornographic in nature, right?
Objection, that's been asked and answered, and speculation.
All right, that'll be, the objection to asked and answer will be overruled.
You can answer the question, ma'am.
Correct,
And after you blocked him, you created a different Instagram account, correct?
yes.
In fact, you've created several different Instagram accounts over the years, right?
No, sir.
You've only created one new Instagram account?
I believe so. I'll change the username for my safety, but I only have one other account.
Okay, but so you've changed the username multiple occasions, right?
Yes, sir.
And so you eventually, through a different username, made contact with Mark again, or he made contact with you? Which was it?
I messaged him.
Okay. And you discussed doing a photo shoot, right?
Correct.
And you and he asked you about doing the photo shoot in lingerie and underwear, right?
Correct.
And you advised the detective of this fact and the fact that you knew that that was the kind of photography he was into, correct?
Correct.
And so when Mark showed up at the car, he was surprised to see that there were all these other people in the car besides you, right?
No, sir.
But that's why he called off the photo shoot, wasn't it?
He said he had to reschedule because he had another person.
But he didn't text you that, did he?
No,
He told you that in person inside your car after you all had driven to pick him up for the photo shoot, right?
correct.
So the only thing that had changed between the time that you talked to him before and the time he got in your car was that there were 3 dudes in the car with you, right?
Can you say that again?
The only
Or
difference
repeat it?
between when you arranged for him to meet you for this shoot and when he got in the car was that there were 3 dudes in the car, right?
He knew there was people there.
Let me ask you a question. May I approach, Your Honor?
Yes.
I'm going to show you what I've marked as Defendant's Exhibit 10. Do you recognize that photograph?
Yes.
Who are the people depicted in that photograph?
My ex-boyfriend?
And you?
Yes.
object to relevance, Your Honor.
All right, if I could see,
Foundation.
if I could see the exhibits, the exhibit, please.
Who is Rashard Horace?
My ex-boyfriend.
You were dating Mr. Horace in roughly 2018 until 2021, something like that?
Objection, relevance,
Sustained.
How long were you dating Mr. Horace?
objection, relevance,
Sustained.
Did you spend time with Mr. Horace after the date, after April 23rd, 2017?
objection, relevance,
That will be
Your Honor,
overruled.
I have to be able to ask.
I've said the objection is overruled.
So you spent time with Mr. Horace after the offense date of April 23rd, 2017, right?
Correct.
And it was a lot of time, correct?
Correct.
You actually at one point moved to Houston to be with Mr. Horace, correct?
Correct.
And during that time period, you discussed aspects of this case and your involvement. Do you recall that?
No.
Did you tell Mr. Horace that
objection, calls for hearsay, both hearsay and improper impeachment.
it's not improper impeachment? Under 613, I have to confront her with the substance of her prior statement.
Objection is sustained.
Oh, we're going to take a vote in a second. Hold on. You testified a moment ago that Mark knew that there would be men in the car with you, correct?
Correct.
But that is not what you told Mr. Horace, is it?
Objection, hearsay,
That'll be overruled.
That is not what you told Mr. Horace, is it?
I never told him anything besides that I had a case.
Okay. You never told Mr. Horace that you intended to get Mark to come for the photo shoot alone with you?
No, sir.
Now, you testified previously that you did not know Mark except as an acquaintance on Instagram, correct?
Correct.
But that's not what you told Mr. Horace, is it?
That is not true.
You told Mr. Horace that you've known Mark since high school, right?
No, sir. I knew him because of high school. He was older than us.
That's what I'm asking. Because of high school, you knew of him?
Of him, correct.
And you also told Mr. Horace that he had tried to violate you on a prior occasion, correct?
No, I did not.
And you also told Mr. Horace that you didn't tell Mr. McIntyre or any of the other people in the car about this past interaction with Mark before getting in the car with him that day to pick him up, right?
No, sir.
And you also didn't tell Mr. McIntyre or anybody else that you secreted a gun underneath your seat in the car when you went to go pick him up that day, right?
That is not true.
You also didn't tell Mr. Horace that when he got in the car, you told everybody in the car about the fact that Mark was a pornographer and that he had done creepy things and that he had tried to do creepy things with you while you were in high school, right?
I never said that.
And you also didn't tell anybody in the car. Well, let me back up. You told Mr. Horace that when Mark told you that the photo shoot was called off, there was a demand to look into Mark's backpack to see if he really was a photographer, right?
No, sir.
And you told Mr. Horace that when you looked into the backpack and there was an examination of this camera, that you found child pornography in it, right?
Objection,
No, sir.
objection, relevant.
Sustained.
Approach, please.
Yes, you may approach. All right, defense, the state filed a motion in limine. Defense, you were aware of the state's motion in limine. And I informed both parties, either side, if you have a motion in limine, before you enter into any territory that's the subject of the motion in limine, that you approach. And the reason why I do that is because, as both parties know, I do not know what the evidence is in your case. I don't know any facts of the case. I'm hearing this case as the jury is hearing it. And in the state's motion in limine, on page 2, it states, the state requests that the court grant this motion in limine and instruct the defense counsel to approach the bench and present the proposed evidence outside the presence of the jury before voir dire, opening statement, questioning, or in any matter bringing any witness or evidence of any of the following matters. And the number one thing says, any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. So, defense, it appears to the court that you've violated the motion in limine, unless you're going to try to tell the court that possession of child pornography is not a bad act.
Your Honor, what I'm trying to elicit from the witness.
No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it in regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm going to have the witness step down. And counsel, you'll take your client to the back. You're still under oath and the rule has been invoked. And what I can tell you, unless you have some photos of child pornography that you're saying that the complainant had, then you're just throwing questions out and you're violating the motion in limine. It clearly states that you all are supposed to approach. Now, unless you all think that child pornography is not a bad act, then I don't know why that's a crime. Because if you're saying it's not a bad act, you asked this witness a question and it involved child pornography. Did I hear that incorrectly?
You heard that correctly, Your Honor, and I'd like to also make aware to the court yesterday when we approached about my motion in limine, the court specifically regurgitated condition number 1 to defense in regards to the nude photos.
Your Honor, I understand that the court is of the opinion we violated the motion.
No, not of the opinion. You violated the motion in limine. The motion in limine says that you are to approach before questioning or in any matter bringing any witness or evidence of any of the following matters. Any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. And you're asking this witness about whether or not he had child pornography or something in his camera. The court considers that a bad act.
Your Honor, to be clear, the questioning of the witness is intended to establish whether or not she previously made these statements. They're not being offered under Rule 613 for their truth. they're being offered for what she said to another individual. That
You are
contradicts
still, what you're questioning her about is a bad act that she said that was the bad act of the complainant. And that's a motion in limine. And you all should approach before you do that. You violated the motion. The court is finding that you violated the motion in limine. And the only question now is how is that corrected? Because nobody approached the court to say, I'm going to start asking questions that is related to number one, to the state's motion in limine.
I understand the court's ruling. I've given my explanation for it. As far as the remedy is concerned, the court will do as it sees fit. I understand.
I know I am, but you're still, it appears to court, acting as though you haven't violated number one, and you have. You violated that motion in limine.
Your Honor,
And I can tell you, yes, counsel?
I think we're shifts slightly, we understand the court's ruling. However, I do want the record to reflect, at least, that what we're asking is what the witness's previous statement. We are not accusing anybody of anything, and we're certainly not trying to accuse Mark, and we will be happy to explain to the jury.
It's still a violation of the motion in limine, hypothetically. If somebody were to ask for it, any defendant, not just your defendant, if somebody were to ask a witness on the stand, hey, by the way, and didn't you tell somebody else that the defendant had possession of child pornography, the defense would be objecting because it's a violation of the motion in limine. It's a violation of the motion in limine in fact and in spirit.
Well, it is intended because this witness gave a number of prior statements. One to a police officer during an interrogation, which was video recorded. Another under oath before another judge in a different courtroom.
But here's the thing, it doesn't matter to the court. What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But instead, you have people who are violating rules, and I'm finding you violated the motion in limine rule. It's not supposed to be brought up until it's brought up to the court outside the presence of the jury. Now, what you have done is by bringing this up, I don't know if the jury's going to believe he was in possession of child pornography or not. I don't know if he was in possession of child pornography or not, because nothing has been presented to the court, and all you all had to do was approach the court and said, Your Honor, I believe we're going to go into number one of the state's motion in limine. And you know what I would have done? I would have had the jury step out, and I would have said, okay, what's the issue here? And you would have told me that, and I would have made a ruling.
I believe this came up yesterday.
No.
Yes.
Not the possession of child pornography.
Of photographs on the camera of
nudes.
Right.
That's it, of nudes. And when we were here at the bench, I even told the state, okay, he has nude photos, allegedly. I said, how is that a bad act? Having a nude photo is not necessarily a bad act.
I see.
And both parties said, yes. Mr. Hunter, yes, Judge, you're right. It's not a bad act. And then we go a step further today, and now it's possession of child pornography. And I'm not going to allow you all to ask that question, and I'm going to instruct the jury to disregard.
We understand, Your Honor.
We understand. And there are some additional matters that she spoke of that have nothing to do with nudity or pornography. And
what would that be?
Your Honor, I don't believe that any other bad acts or potential bad acts of Mark Anthony Saldivar will be discussed other than those things which were discussed in opening statement related to the.
I'll determine whether it comes in or not. And you know why I'm going to determine whether it comes in or not? Because there was a state's motion in limine that says any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, you'd approach beforehand. And I need to make a ruling on whether or not it's relevant and whether or not it should be admissible. That's me. That's my job.
I understand your.
So what other acts or bad, I'm sorry, what other bad acts that you feel, I'm sorry, crimes, wrongs, or bad acts of the victim, Mark Anthony Salvador, that you feel this witness is going to be questioned?
I can tell the court that it's going to be, and I don't know if there'll be disputed or not, that he damaged the vehicle. I guess that could be considered a bad act. I want to.
Well, with regards to the damage of the vehicle, allegedly, it said that he put his foot through the glass of the vehicle. That's a part of this whole alleged offense and the offense date. So, counsel, you all know that if there's evidence that's going to come in that he damaged the windshield, that's already in through other people.
Right, and the issue of what she said back to that, to our client, she says that she didn't say anything, that she looked straight ahead, didn't look to the side.
All right,
didn't
so
look
here-
behind.
here-
May I just finish?
We're getting off track. We're with the bad acts.
Well, I'm gonna suggest that she has told people, and I believe if she says that's correct, that I never said anything other than that, to Mr. McIntyre, part of the race gesture, the offense, if she said something other than what she told the police officer, I believe that's a prior inconsistent statement, and we're entitled to ask her about it. And by the way,
I'm
it
not
has nothing
challenging-
to do with
I'm not challenging,
pornography, sex, anything else.
counsel, I'm not challenging anyone on inconsistent statements.
Okay.
I'm not challenging anybody on that. The court knows the rules of evidence. What I am saying is there's a motion in limine. And I think it's safe to say for the people who have been practicing even a year that you know you're not supposed to violate motions in limine. And number two, if there's an alleged offense and videos have been shown in exhibits that it's alleged to be, or maybe the jury feels it's already been established that the person who kicked in a window or damaged the window of a vehicle is the complainant, because witnesses have said it's the complainant who did that. So you all know questioning the witness about that, that's really not about the motion in limine.
That's
The
where
motion
we're
in
going.
limine is about your co-counsel violating it.
My able co-counsel, I can tell you if I can get 5 seconds, I believe he will go into next the matter of what was said that precipitated the fight.
All right, let me
And
just-
I don't think it's about anything, and I think we're entitled to ask the witness.
Let me just tell you,
Yeah.
you violated the motion in limine.
We got, I'm,
You will not ask this witness any questions about child pornography on a camera unless you have
we agree.
proof
We're
that
not-
there's child pornography on a camera.
Well, by the way, we do have proof of that,
Mhm.
and it was a legitimate question. However, for the court's ruled on it. That's not what I'm discussing. I'm talking about what we're gonna do next. And while I can't look into his mind, I presume since the court has ruled on it, we can make a bill later, but we're not gonna do anything in front of the
Yeah.
jury. However, I do believe conversation, what she tells the police officer, what she tells the judge, if there's somebody that says you said something else, I believe that's fair game, that's impeachment. And all I don't want to do is, we shouldn't have to have the hearing like this before we ask every question.
No,
And if it doesn't involve child pornography or some extraneous offense, I think we're
no,
entitled.
you all have to have a hearing because it's a part of their motion in limine.
Not
you can't
if it's
just-
not an offense.
Here's,
Or
yes, and
misconduct.
and the last time I checked, possession of child
And we
pornography.
agree.
It's an
And-
offense.
And we're gonna be chastised and the court's gonna do something.
Oh, no, my chastisement is just stating the law. There's a motion in limine in place and the defense has violated. And I am not going to allow you to ask questions about child pornography.
We're not gonna do that based
All right.
on the court's ruling.
Let's
However,
let the
we
jury
should be
Your
able
Your Honor,
to.
just in anticipation, the only other aspects of this questioning that I believe will venture into territory that the state might object to would be questioning about whether or not she had a hand in getting the gun into Mr. McIntyre's hands, if that is in fact what happened. And secondly, whether or not she is the source of the marijuana. which I'm not clear on. There are.
All right, so here's the thing. And let me just tell you, this is what well, I'm going to say this.
She was asked that.
This is what I'm going to say, and I want you all to listen to me clearly. Both sides have been practicing law for more than 2 seconds. Everyone here knows that if you're asking questions and those questions are related to what's already been brought in evidence, the marijuana, it's already in there. It's already in the evidence. Who had it, what they did with it. Yeah, you can ask questions about that.
And guns.
What?
And guns.
The gun, it's already there. But I don't want any deflections where people are pretending as though they don't know that they violated the motion in limine. So I'm bringing the jury back in and I'm telling them to disregard the last question. I'm telling them to disregard any testimony or questions about child pornography. Does everyone understand?
Yes.
And the defense, you violated the motion in limine. All right, each side, you all have 30 minutes. You ready? Oh, just one second. We're back on the record in 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announce?
Megan Galloway and Jason Garahan for the state of Texas.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre. He's present in the courtroom. We're ready to proceed.
All right, let's bring the jurors in.
All right, for the jury.
All right, ladies and gentlemen, you've heard all of the evidence that you're going to hear in the case at this time. So ladies and gentlemen, each side is going to have 30 minutes to present their closing arguments to you. If anyone needs a break now, we can do a brief break for you now, or either both sides are going to proceed with their closing arguments. All right, State, you may proceed.
In the world of Tamar McIntyre, Mark Anthony Saldivar was a nobody. Tamar McIntyre took Mark's life in that Chick-fil-A parking lot. He discarded him there like a piece of trash, and then when he got to El Potosino restaurant, he celebrated his slaying. Ladies and gentlemen, Mark Anthony Saldivar was a somebody. He was a good son, a brother, a friend, a photographer, and tragically, he was the victim of a capital murder committed by the hands of that defendant sitting right there. And we're going to talk about the law that supports that. Now, in your jury form, you have the lesser included offenses of manslaughter and murder. Now, manslaughter is if a defendant recklessly causes the death of an individual. Murder is when the defendant intentionally or knowingly causes the death of an individual, or the defendant intended to cause serious bodily injury and committed an act clearly dangerous to human life that causes the death of an individual. Now let's talk about the mental states. Intentionally is legally defined as a conscious objective or desire of the defendant. Knowingly means that the defendant was aware of the nature of his conduct and the circumstances that existed. Ladies and gentlemen, this is not a manslaughter case. The defendant did not act recklessly. An example of manslaughter would be somebody waving around a firearm and they believe the safety is on and it goes off and kills somebody. That's not what happened here. The elements of capital murder. The state has proved these elements to you beyond a reasonable doubt. You heard multiple witnesses testify that this offense occurred on April 23rd, 2017. It occurred in that Chick-fil-A parking lot in Bexar County, Texas. You heard testimony that the defendant, Tamar McIntyre, was the shooter and that he was committing a robbery when he took Mark Anthony Saldivar's life intentionally, shooting Mark Anthony Saldivar with a firearm. Ladies and gentlemen, the law doesn't require you to be a mind reader. You can infer intent from words and circumstances and facts that surround the offense. So let's look at that. The defendant acted intentionally. He had his firearm displayed from that stoplight at McCullough. He had his firearm displayed the whole time to Chick-fil-A, and he opened his door, leaned half in and half out, and shot Mark Anthony Saldivar. Those are intentional acts. Now, regarding the robbery. Robbery starts at theft. Theft is the unlawful appropriation of another's property, and it is unlawful if you do not have the consent of the owner. What are the facts that prove theft here? You heard Lucy Saldivar testify that she gave her son Mark $10 before he went in that black Kia Forte. The physical evidence that supports the theft is Mark's wallet being at the Mexican restaurant. You see Jalen Bell putting on Mark's backpack at the Mexican restaurant, and Jalen Bell discarded Mark's phone there in the Chick-fil-A on their way out of the Chick-fil-A parking lot. Further, you heard Hester Rogers testify that the back passenger was yelling for help after being forced out of the vehicle. And Joanna Reyes testified that Tamor made the demand for Mark's backpack, Mark refused to give it up, and Tamor had possession of the backpack when Mark was forced out of the vehicle. And Joanna further testified that at the Mexican restaurant, Jalen Bell was mad because there was only $10 in the wallet. Now, how do we get to robbery? It is committing the theft while causing bodily injury to the victim to maintain control or retain control of the property. Ladies and gentlemen, you've heard multiple witnesses testify to that. And the photos from the ME, you saw the knot that Mark had on his forehead. You saw the contusions that he had near his nose and his mouth. That proves robbery. You heard multiple witnesses testify. Ashley Buenteo testified the front passenger used the handgun to strike the back passenger. Paul Caballero testified that the front passenger was fighting the back passenger. Hester Rogers testified that the front passenger was brandishing the firearm while fighting the back passenger. And Joanna Reyes testified that Tamor beat Mark and took possession of Mark's backpack. Now, I want to talk to you about the law of parties. Our law provides that a person is criminally responsible as a party to the offense if it's committed by his own conduct or the conduct of another. Jalen Bell and the defendant fled San Antonio with Mark's belongings, and this defendant, even though we have proved that he is the shooter, should you choose to not believe that, he is still criminally responsible for what happened in that car and for the death of Mark Anthony Saldivar, because he was an active participant in the beating and taking of Mark Anthony Saldivar's property. Now, when you retire to the jury room, if you find the defendant guilty of the offense of capital murder, your deliberations stop there. If you do not find him guilty of capital murder, then you would proceed to the lesser included offenses of murder and manslaughter. There are possible defenses to murder and manslaughter, and we'll talk about those. They're in the jury charge. It's self-defense and defense of a third person. Now, just because these affirmative defenses were submitted to you does not mean that the court is indicating anything to you, or that it's just that the defendant is entitled to those affirmative defenses, and that's why they're in the charge. Now, let's talk about self-defense. A person is justified in using force against another when and to the degree the person reasonably believes that the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force, okay? A reasonable belief is a belief that's held by an ordinary and prudent person. The use of force in this case was not justified for many reasons. One, Mark was not using unlawful force against the defendant. He was merely trying to obtain his belongings back. There's no evidence that Mark ever injured the defendant or even engaged with him in the physical fight. Furthermore, the defendant provoked. If you do see if you do find that Mark did use some type of force against the defendant, that force was provoked by the defendant, okay? The defendant is the one who put all of these acts in motion. And the defendant never abandoned his robbery of Mark Anthony Saldivar. And I'll tell you what abandonment would have looked like. Defense is going to get up and argue, oh, the gun was just up in the air, you know, oh, the gun was put away and then taken out again at the Chick-fil-A. No. What abandonment would have looked like in this case is giving Mark his things back and driving off. But that's not what happened. And you see that in the Chick-fil-A video. Now, talking about deadly force, it's pretty much, thank you, Judge. It's pretty much the same as what I just described, except the person that the defendant is acting against has to be using or attempting to use unlawful deadly force. Mark Anthony was not using any deadly force against the defendant. And the defendant does not get the presumption of reasonableness because he provoked Mark, and the defendant was engaged in criminal activity, and that is that robbery. A person is justified in protecting a third party if they believe, or if they would have been justified in using self-defense themselves, which we've already established that the defendant was not entitled to. And the use of deadly force was not justified in this case because Mark was not using deadly force against anyone in the car. They were all using deadly force against him. Now, you all heard many witnesses in this case, and you're the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. Now, I want to talk to you about the accomplice witness rule. Now, if you believe that Joanna's testimony naming the defendant as the shooter is true and shows the defendant guilty, you have to further believe that there is other evidence in the case to substantiate what her testimony was. And at that point, you can then find the defendant guilty. So let's talk about the other evidence in the case that tends to connect the defendant with the offense committed. The 911 calls, the lay witness testimony that you've heard. And defense is going to get up here and they're going to tell you, well, there were inconsistencies. Ladies and gentlemen, that's normal. There were multiple witnesses in this case, but they were not consistent about the important parts of this case. Who had the gun and who was in the front passenger. And they're going to argue, thank you, Judge, they're going to argue about the race. Some people said, oh, it was all Hispanics. I urge you to consider where the witnesses were. Elizabeth Adams did say she believed that the occupants of the black Kia Forte were Hispanic. She was standing in the Doubletree parking lot. Everybody that was in the vicinity, Hester Rogers, who was standing right there on the curb, described him as a medium-skinned black male. And the occupants of the car, Ashley Buenteo and her uncle, described a black male as well. The Chick-fil-A video, the El Potosino video, the letter in the clothing and the trunk, the phone records, and the digital evidence all corroborate and tend to connect the defendant to this case and being the shooter in this case. The blue phone that was found in the front passenger glove compartment. Ladies and gentlemen, that digital evidence is telling you who is the owner of that phone. TK47 iPhone and TK47U at iCloud.com. That's the owner of that phone. Now, you have in State's Exhibit 141 phone records from Joanna Reyes's phone. And I want you to take a look at those, because what you will find is if you compare the phone records from Joanna to the call logs in the defendant's phone, which is State's Exhibit 140, you're going to see some overlap, which corroborates Joanna. That first phone number up there was last called in the defendant's phone on March 11th of 2017. The defendant had communication with that phone number 6 times. Beginning on April 23rd, 2017, Joanna's phone calls that number 20 times. The next number, the defendant had communication with that number at least 43 times, and the last call was on March 8th of 2017. Beginning on April 25th of 2017, you'll find that number 8 times in Joanna's phone records. And that last number, The defendant had over 80 interactions and last called on March 8th of 2017, and there's 14 calls from Joanna's phone beginning on April 20th of 2017. All of those things corroborate Joanna. Further, in that blue iPhone, there's a picture of the defendant wearing the slides that were in the car and are pictured in State's Exhibits number 126. Ladies and gentlemen, at this time, your sole duty is to determine guilt or innocence in this case. The state is not required to prove our case beyond all doubt, just beyond reasonable doubt, and we have proven our case to you. You are not to let bias, prejudice, or sympathy play any part in your deliberations, and you have taken an oath to render a true verdict according to the law and the evidence in this case. Ladies and gentlemen, that verdict is finding the defendant guilty of capital murder. Thank you.
All right, defense.
Thank you, Your Honor. Just a moment to switch.
Yes.
May it please the court, opposing counsel, ladies and gentlemen, thank you all for the patience that you've given us and the sacrifice of your time. This is an extremely hard decision. It might be the most grave and serious thing that you consider, deciding the guilt or innocence of someone charged with capital murder. Taylor McIntyre is not guilty. He's not guilty of capital murder. He's not guilty of murder. He's not guilty of manslaughter. And the reason for that is very simple. If you're going to charge someone with that kind of an offense, if you're going to take their liberty away from them, then you have to do it right. You have to do the work. And as this case clearly demonstrates, the work wasn't done. The investigation was faulty, it was incomplete, and by and large, I think it could be summarized as the detective looking at it all and going, good enough. It's not good enough, and you all need to insist on more. If you recall the testimony of Detective Juarez and my cross-examination of him, I think I've given you a clear roadmap about what this case is about and what it isn't about. We all understand that there's a pool of physical evidence, and there is testimony conflicting from different innocent bystanders. That information is not enough to convict anyone of a crime. None of the people that were in that car could be convicted on the physical evidence alone that was provided. And everything else that flows from this is the bought and paid for testimony of the accomplice witness, Joanna Reyes. And there is not sufficient corroboration. The law prevents you from convicting Mr. McIntyre solely on the testimony of that accomplice. Let's talk about the physical evidence. We know that there's a 9mm shell casing found outside of the Chick-fil-A. We know that we have a dead body who died from a gunshot wound. We don't have a bullet. At the very basic core fact, the state can't actually demonstrate that 9mm shell casing and the death are connected. We have gunshot residue on the deceased's hands. We do know that a 9mm handgun was seized off of Jalen Bell in Dallas a few weeks after the shooting. We have a black four-door Kia with a shattered windshield. We have some grainy surveillance footage from the Chick-fil-A and from El Potosino restaurant that doesn't identify anyone, that by itself would not be able to give you any indication of who those people were. We have the discarded cell phone of the deceased. We have fingerprints from Jeremiah Rodriguez. We have fingerprints from Jalen Bell. That blue iPhone that the prosecutor spoke of. A photograph of Mr. McIntyre and Joanna Reyes, and a letter addressed to Mr. McIntyre. So dirty laundry, toothbrushes. We see very significantly a .380 auto bullet, a live round in the front passenger seat, the seat that they insist Mr. McIntyre was sitting in based upon nothing other than the bare word of Joanna Reyes. But nevertheless, a .380 auto round, a bullet that you know could not have been fired from a 9mm. We have a condom in the back seat, a wallet, broken sunglasses, a necklace pendant strewn about in the El Potosino parking lot, a broken SD card. We have these innocent bystanders. And yes, it's normal that people going about their daily lives aren't going to give detailed accounts of that, but don't accept that as some kind of an apology for the state's shoddy investigation. That's not how you should interpret that. Yes, it's normal that innocent bystanders are going to give conflicting accounts, and so that evidence has to be weighed less than it would if someone was able to give a definitive account. You have no eyewitness identification of Mr. McIntyre. You have no eyewitness identification from any of those people of any of the participants in the car. And their accounts differ. We have people saying that all of the members were Hispanic. We have people saying that the man was African American. That doesn't do you a whole lot of good. There are 2 African American people in that car. They conflict about how many shots were fired. How many guns did they see? What exactly was the person doing with the gun? They largely do agree on one important fact, which is that Mark jumped on the hood of that car after he was ejected from it and stomped on the windshield. But let's talk about what you don't have. Each of these things is something that is very important for you to be asking, why don't I have it? And what would it have told me that might have informed my opinion one way or the other? Is that SD card that they found in the parking lot even compatible with a digital camera? Is it compatible with the kind of digital camera they say Mark had? You don't know. We have no idea. What was on the SD card? You don't know. Fingerprints of Tamor McIntyre, you don't have any. None. Any reliable witness who can identify Tamor McIntyre, not even the 2 women going to the massage parlor that day, are able to give a definitive identification of Mr. McIntyre or anybody else that got into that car. An accounting of where the car was in between the time it departed Chick-fil-A and the time it parks at El Potosino. I mean, if we're going to really latch on to this idea that Joanna Reyes says that Tamor was in the front seat and we see somebody getting out of the front seat, aha. Well, okay, we don't know that that's Tamor McIntyre getting out of the front seat, and I don't know what they were doing between the time period that we're in the Chick-fil-A and we parked at the restaurant. They could have stopped to buy cigarettes. They could have stopped and decided to do a Chinese fire drill for some reason. You have no idea, and they don't either. They're asking you to just jump over that. And you're not supposed to be making those kinds of elisions in your logic. You're not supposed to be making those kinds of jumps. That is not common sense. That is not upholding your duty. That is taking their word for it. And that's not what you're allowed to do in a criminal trial. You never get to take their word for it. Their burden of proof prevents it. His presumption of innocence prevents it. You don't have any GPS data from any of these phones. You don't have any cell tower location data. We have warrants showing who called who. Okay, great. Tamor McIntyre and Joanna Reyes were dating. They called each other. That's not a smoking gun of anything. But that cell tower data could have also told you where they were and when they were there, and you don't have it. We don't have a dump of Mark's cell phone. We don't know anything that's on there. We don't have any idea what their communications actually were. We don't have a dump of Joanna Reyes' cell phone. We have no idea where her communications were. She says somebody broke it up in Dallas. We have to take her word for that. We have no corroboration of what Joanna Reyes did at any point in time after we last see her on that El Potosino video, and we only know it's her on the video because she says it's her. We don't have any examples of Mark's work as a photographer. This claim that it's his passion, this claim that that's his thing, this claim that that was his reason for being in that car, they're asking you to take their word for that. There's no proof of it. We don't have a single example of this man being a photographer. We don't have a digital camera, the subject of this supposed robbery, or anything connected with the digital camera. We don't have a backpack. Technical difficulty, Your Honor, I apologize. When it comes to the gun, we have problems there too. You heard testimony that you could do additional GSR work on the hands of Mark Saldivar to try and determine whether or not there might be additional elements besides lead, barium, and antimony that might give you a key as to what kind of ammunition was used or what gun was fired. That analysis wasn't done. You heard testimony from a firearms expert saying that it couldn't have been the gun. But fundamentally, he admitted at the end of the day, it's a subjective science. It's the human eye that's at work here. And he's basing it off of mostly the indentations on that primer. And while he can say that the breech face precludes it from being the same thing, he didn't take the gun apart. So he's speaking about generally what a Smith & Wesson looks like. And he can't speak to the condition of the gun. It's been sitting in evidence for years, 7 years, in 2 different property rooms. And no one came here to talk about whether those rooms are climate controlled, to talk about whether they have an armorer that comes in and cleans the guns. Nothing. And he acknowledged that corrosion can affect how the primer gets indented when it's fired. He had nothing to analyze on those gun magazines, 2 of which are also 380 auto, not associated with that shell casing. And 1 is a 9mm. We don't have fingerprints on those magazines. We don't have anything to tell us whether they're significant or whether they're not. Except we do know that there were a lot of guns in that car. We know that the perimeter of the crime scene didn't include the access road, which seems to me to be a problem when we don't know how many shots were fired. Because maybe there are more shell casings. There's no way to say one way or the other. This is really important. We have no search of Jeremiah Rodriguez's home. I'm sorry, but their only witness, the accomplice in this case, says that everybody left that parking lot and went to Jeremiah's house. If we're trying to find proof that someone committed a capital murder by robbing somebody else, don't you think we should search the house that they all ran away to afterwards to see if we might find something? Nothing. You didn't hear from Jeremiah Rodriguez. You didn't hear from Jeremiah Rodriguez's family. You heard nothing about that aspect of the case, which would be the best place to find something that might corroborate anything that Joanna Reyes said. They didn't give it to you. This is a homicide investigation. It's a capital murder investigation. A police officer doesn't get a warrant for a critical scene in the case. There's no search of Joanna Reyes's house, her parents' house. She says that she went to Dallas by the Greyhound bus station. You don't have any footage of her leaving. You don't have any records that she ever bought a ticket. Do we even know that she went to Dallas? There's nothing to prove that Joanna ever spoke to Tamar McIntyre again after the 23rd of April, 2017. They have some call logs that show Joanna tried to call him. But that doesn't seem very consistent with what Joanna tries to claim, which is that Tamar was an aggressive and possessive person. Very significantly, you don't have DNA, and you know that they could have tried to get it. They swabbed Mr. McIntyre's cheek, but they decided that it wasn't necessary. They didn't care what the results were. That's inexcusable. One of the witnesses in this case, Jeremiah Rodriguez, lied to the detective for a full interview about there being a 6th person in the car named John. And we don't have DNA to try and determine who's telling the truth and who's not. We're just going to let his gut steer us in whatever direction it goes. Oh, I think you're lying to me. We don't have DNA on the 380 auto bullet. We don't have DNA or fingerprints on the gun magazines. We don't have fingerprints or DNA on the condom. We don't have any testimony from the lead evidence technician, Kim Wong, who did all of the barcoding from the crime scene at the Chick-fil-A to know whether or not the evidence is all accounted for, correctly labeled, and that it was even available to these laboratory analysts to look at. And you know that mistakes were made because they, for years, had a 9mm shell casing labeled as a 40 cal. You don't have any testimony from Jeremiah. You have nothing from Jalen Bell that was said back then or now. Just a complete mystery. 2 weeks of trial. All of those witnesses. This stack of physical evidence here in front of you. What do you have? Tamar McIntyre was in the car at some point. Was he there on that day? Maybe. Maybe not. When was he last there? They can't tell you. Did he have a gun? They can't tell you. Did he shoot a gun? They can't tell you. Did Mark start this fight? They can't tell you. Was there a fight? They can't tell you. They can't tell you a single thing about what happened inside of that car at all from any of the evidence that's piled in here. Now, their theory, as you know, rises and falls entirely on the testimony of Joanna Reyes. Proving that Tamar McIntyre was in that car is not enough to convict him of anything. Mere presence at the scene of a crime is not enough. The jury instructions tell you that explicitly. As a party, as the primary actor, doesn't matter. Mere presence is not proof beyond a reasonable doubt. It's the law. Joanna Reyes is lying. You know she's lying for several reasons. First, Detective Juarez knows she's lying. Everyone knows she's lying. The state bought and paid for that testimony at an extremely high price. Joanna Reyes was an adult when this crime occurred. She is facing life in prison without the possibility of parole or the death penalty for a capital murder. And rather than facing those consequences, the state offered her a plea to tampering with evidence with deferred adjudication, meaning that she'll never have a felony conviction for this offense. She'll be eligible to have it non-disclosed, meaning that when she goes out there to apply for a job or get an apartment or do anything, this can be ignored. Won't be on the radar screen of people out there in the free world. And even though it's a 10-year term, the terms of the agreement allow for them to knock off time as things progress, so long as she's truthful. But we all know what that means. There's only one arbiter of whether she's truthful, right? They're not looking at your verdict to decide whether she's truthful. Don't worry, you're not deciding whether Joanna Reyes gets a better outcome or not. The only thing that decides whether she's truthful is what they think. The ones who are calling her to testify. That's not an acceptable way to run a justice system. Compensating people with their freedom to obtain the critical information they need when none of the physical evidence supports it is not a way to run a justice system. Her inconsistencies in her testimony are too many to recall. I don't know if I'm going to be able to list all of them. I know for certain that while Joanna maintained for a long time that this was all Tamor's idea, and that Tamor was the one talking to Mark on the messaging system, and this was what Tamor wanted, and it wasn't me, you heard her on the stand acknowledge that after lying and minimizing that forever and ever and ever, she finally has decided that she can say, all right, well, he contacted me first on Instagram, and he solicited me for nude photographs, and I blocked it. And then I later changed my account, and we got in contact again. And then we talked about this photo shoot, and he wanted it to be in lingerie. This is all about her career as a stripper. There is no evidence that this is actually anything that Mr. McIntyre wanted. There's no evidence that Mr. McIntyre was even aware that she was communicating with him. You have no way of knowing that other than her claim. A claim that she has every incentive in the world to say, irrespective of whether it's true. The idea that the photo shoot was rescheduled as to called off, I think, is an interesting thing. You heard testimony, Mark didn't have any other appointments, and the testimony was that he was basically saying, we're not going to do the photo shoot, but give me a ride to North Star Mall, which is where we said we'd do the photo shoot to begin with. That doesn't make sense. That doesn't make sense. She's hiding something there. I don't know what it is. I can't tell you what it is, but it's not my job to. They have the burden of proof here. And at its core, nothing corroborates her claims. If you want to tell a policeman that despite what it looks like, you are not the getaway driver or the perpetrator or involved in an armed robbery and a death that occurred in the Chick-fil-A parking lot, that it really was all a big misunderstanding, which is what she tried to do desperately for a very long time, you would show the detective your communications with the deceased to clear all of that up. And you would explain how that all develops on. We don't have any of that. She didn't give you that corroboration. And that malarkey about someone broke my phone, they have nothing to back that up either. We also know she's full of it because, come on, I thought he was 18. Look at the photographs. No one would mistake that child for an 18-year-old man. He's a 16-year-old boy, and she knew it. She was afraid. She had court the next day. There are bailiffs in every courtroom in America, policemen, everywhere. If she was afraid that she was going to have something happen to her because of what she saw, ample opportunity existed. She spoke to the detective, in this case, on the telephone. She gave her fingerprints and her ID when she went to go dance up in Dallas. She had her father take her to the bus station, passing up opportunity after opportunity after opportunity. You have to first believe the accomplice before you even go into this question. You don't get there. I don't think anybody can get there. And then, even if you do believe her, you still have to have independent corroboration that connects Tamor not to the scene of the crime, not to the car, but to the commission of the offense. You have nothing. Not a shred of evidence supports that. Zero. Nothing corroborates her story. The justice system in America depends upon the state having to meet an exceedingly high burden. It should be extremely hard to put someone away for capital murder or manslaughter. They haven't given you that. Demand more. Expect more. It is okay to have your doubts, and it is okay to rely on those doubts. It is your duty to expect them to work to dispel them, and they haven't. And lastly, I just want to say, we're counting on you. Tamor needs your help. If y'all don't hold them to their burden, we're going to have a miscarriage of justice today. No one wants that. I count on you to do your duty. I know that you will return a verdict of not guilty as to all of the theories the state has put forward. Thank you. Mr. Goals.
It's going to take me a few minutes. I have to change computers. May I have a restroom break? Ladies and gentlemen of the jury, able counsel, Tamor. This is a capital murder case. It's an important case, obviously, to Tamor. But I think we all take it seriously. I've been watching. I can tell you that I'm impressed. I'm going to try and just summarize quickly. Judge Boyd is the judge of the law. She decides the law. You've been watching her rule. I told you we were going to have some disagreements. Objection, instruction, don't disregard. I don't know how y'all keep track of it. We're having trouble keeping track of it. But y'all been paying attention, and I think you've been following those instructions. But y'all, each and every one of y'all, are the judge of the facts. The sole judge of the facts. Each and every one of you, in your own mind, you make these decisions. No one will ever be able to come back and look into your mind and ask you about that. That's important. This is Tamor's case. I told you I was going to summarize, so let me just tell you that there were a lot of inconsistencies. I told you a lot of this was going to be kind of boring. It's like watching paper. I mean, you sit there and watch over and over again. And I said, that's because that's their job. They've got to do it. They're able counsel. I respect them. They're trying. And they've got to put that before them. But there are some things in dispute. One of the things I talked to you about was inconsistency. There were a lot of inconsistencies here. For example, one of the witnesses, I think her name was Ashley Buentello, she said there was a female driver. Another said they saw only females in the car, and that was Eliza Adams. Another said there were two males in the front seat. That was Anna Delgado. Some said there was one shot. Some said there were two shots. There were others that said there were three shots. Joanna Reyes, who we're going to be talking about her at the end. You heard able co-counsel John Hunter talk about Miss Reyes. She said she couldn't remember. She was in the car. She couldn't remember how many shots. we're going to talk about, you've already heard some things about the police investigation. I kind of like Sergeant Detective Raul Juarez. He's an able and he's professional. But let me just tell you, despite all the swabs they took, you saw the officers swabbing each parts of the car, all the evidence. It's interesting. They never took they took our client's DNA, they never compared any of that. There was no effort to do that. Why? The 9mm weapon, the one seized from Jalen Bell, it was never even compared to the spent cartridge. It sat there for 7 years in Fort Worth. Then it was brought to San Antonio. That wasn't done until we asked for it. 7 years later, they had never done that. I don't think guilty people would be asking for that sort of thing. The spent round, the one spent round found, where was the lead crime scene investigator, the CSI? Remember the woman? The only way I remember is that they had a lot of pictures of her high heels. There's nothing wrong with high heels. My wife for 55 years wears them all the time. But where was she? She's the one that picked up all that evidence. She's the one that bagged it all. Remember? Where is she? That nice homeless woman, she managed to get here. They have the burden of producing evidence. Where is the officer that made that you saw the report? It's in the evidence. The report where he says it's a, what did he say it was? A 40 caliber, the 9mm cartridge? That was a mistake. Is that a giant mistake? Is that a reasonable doubt? I don't know if that's a reasonable doubt. But we're talking about cumulative. This is not our best efforts. There were no fingerprints obtained from the vehicle of Tamor. Didn't they compare any prints? There weren't any done. There were no fingerprints of the magazine. Remember, there were 3 magazines found, only one of them a 9mm that he just showed you. It fit perfectly in the weapon seized from Jalen when he was arrested 5 days later. There was no search of any residence. Why is that? I mean, you see it all the time whatever you watch on TV, when they're trying to find people, they always go to their residence. They seize their residence, look through their electronic media. There was no search of Joanna Reyes' residence. There was no search of Jalen Bell's residence. There was no search of Mark Saldamar's residence. There was no search of Jeremiah's residence. Remember Jeremiah Rodriguez? That's where they went right after this happened. Why wouldn't you want to search there? Why not? Well, our able detective said there wasn't any need to. He had made it. He doesn't get to make. The law is very clear in this state. No witness, no matter how much we like them and no matter how professional they are, no witness gets to make your decisions for you. No witness gets to tell you who's guilty and who's not. Not in this country. Y'all get to decide. He decided that early on. That's why he didn't do it. He told you. I didn't think I needed to. Jalen, let's get to the facts of this here. Do all those things amount to a reasonable doubt? Do any one of them amount to a reasonable doubt? Do they cumulatively, all of them together, amount to a reasonable doubt? I don't know. That's your decision, not mine. But it's certainly in the best performance by our San Antonio police force. Jalen Bell, he had, there was only one 9mm retrieved in this case, and it was seized from him. And remember the testimony by Joanna Reyes? Yeah, he had a gun that day. He always had a 9mm. This guy, he always was packing. And it was a 9mm that he packed. Think about that. There was one spent cartridge found that they didn't even compare until we asked for it 7 years later. And one weapon, 9mm, one cartridge, 9mm. Was it but you know, Jalen Bell seemed to always have a 9mm with him. That was how he ran. Jalen Bell's are the only fingerprints they took, and they were on Mark Saldivar's telephone. Jalen Bell. Remember, that guy's a big boy. 6'4", 240 pounds. Tamor, little slight. 15 when Joanna Reyes met him. 16 when this happened. Jalen Bell's the one that rummaged through the backpack. He's the one that the testimony is rummaged through the wallet. What about him? Why not search his house? Where is he? We don't have any obligation to not. You heard the charge. I know it's long, but take a look at it. It tells you that we don't have any obligation to bring any evidence, not to call any witnesses. It's the prosecution's burden, a heavy burden. They have to prove beyond a reasonable doubt every element of the offense. Why didn't they bring Jalen Bell?
Time.
I thought I was going to get a 1.
I did. All right, thank you. All right, State, are you prepared to proceed? You have remaining 16 minutes and 47 seconds.
You know, may I have, I prepared this last night. Can I just have a few minutes more?
No, both sides agreed to 30 minutes. That's what both sides are receiving.
I'm going to beg the court, can I have 2 minutes?
No. All right, State, are you ready to proceed?
Ladies and gentlemen, I'll be the last one speaking to you. I know it's been a long 2 weeks, so I'm going to try to be as brief as possible. As you notice, the judge is going to hold me to a 16-minute time interval. So after I speak with you, you're going to have the opportunity to go to the back. The charge that the judge read to you, you're going to get that, a copy of that, and you're going to be able to review that back there, okay? So what I'm going to do is jump right in. And about the capital murder here. The state has proven every single element of capital murder. If you look at this on April 23rd, most of these are not in contention here. April 23rd, 2017, Bexar County, Texas. The death of Mark Anthony Salvador was by a deadly weapon, by a firearm, by a shooting. And the only thing in contention that defense is arguing is Tamor McIntyre was not the one that did this while he was attempting to rob. I think the evidence overwhelmingly, if not beyond a reasonable doubt, beyond almost all doubt, that we have the correct individual. I'm going to talk about Joanne Reyes briefly right now and then go over evidence with you that came on in this case. Right here, I'm going to read it to you. Joanna Reyes, accomplice. She is an accomplice to this. She did plead to tampering with evidence of that car. She fessed up, took responsibility for her part. She did not shoot Mark Salvador. That man right there did. That's what we're trying to do, is make somebody that killed someone take responsibility. Joanna took responsibility. You look at all the evidence. Joanna did one thing. She was driving that car. You saw when she got out of that car. She's freaking out. You heard testimony from Jasmine Cruz saying she looked freaked out. If you watch that video, what are those two other individuals doing? Jalen Bell, 6'4", 200-something pounds, and the slight individual, Mr. Tamor McIntyre, walking around like it's another day. A day in the life of Tamor McIntyre. A day in the life. That's what Joanna gave you with her testimony. That's what she gave you. A taste of the life of Tamor McIntyre. A person that shot down another individual for the sole purpose of taking a camera and a backpack and $10. That's a day in the life of Tamor McIntyre. Just one day. She was an accomplice, but she took her responsibility. Defense counsel's correct. She's getting deferred. She's been on bond for over 7.5 years. As abided by that. has not broken the law, has not broken bond. She came in here and testified. And you know what people do, or what they're labeled as when they testify? Snitches.
Your Honor, may we approach?
All right, State, you may continue.
Thank you, Judge. Ladies and gentlemen, I'll go into Joanna Reyes. She is an accomplice, but she took her responsibility, has taken her responsibility. Her testimony needs to be corroborated by other evidence tending to connect the defendant with the offense. Tending, not beyond a reasonable doubt, just connecting him, tending to connect him, okay? Keep that in mind. But then, after you find that evidence, that corroborating evidence, you add that with all the other evidence that came into this case, including her testimony, including what she said, and everybody else said, all the evidence, and then you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. The corroborated evidence that corroborated her, and then also all the evidence, including her testimony, equals a guilty in this case. Let's go over that. This is the video. I want you to watch this video if you need to over and over, unless you've seen it enough already. The fact is, if you watch that video, one, Mark Salvador stomping on that windshield. No doubt that he stomped on the windshield at some point. But you watch that car and it lurches forward, what does he do? He falls down on his hands and knees. He slides off that vehicle as it goes back. Then you see the white shirt pop out. Boom. If you listen to the ME's testimony, that individual was shot in the shoulder. Mark was shot in the shoulder. It was from left to right, downward, from front to back. He wasn't standing up stomping on a windshield. He was on his hands and knees, being shot by Tamor McIntyre to his left. It went across his body and exited out his lower part of his back. Look at the evidence. He was not stomping on a windshield when he was shot. You see it from that video. Chick-fil-A video. The corroborating evidence in this particular set is the fingerprints of his accomplice, Jalen Bell, that has been testified to thoroughly. Jalen Bell is best friends with Tamor McIntyre. They still had contact after this. They still had contact, much contact, up until months ago. In fact, if you listen to State Exhibit number 118, you hear Tamor McIntyre say, I gave Pimps money. Gave him money, so why did he give him money? But Joanna Reyes is getting bought off. Remember that. Fingerprints of the accomplice Jalen Bell, best friends. The jail calls tell them about that best friendship, and also money being transferred to Jalen Bell from Tamor McIntyre. They arrived together in town in San Antonio, and then they left together and escaped off, one to Dallas. Jalen Bell gets caught there, but if you listen to the testimony of the officer there was another individual with him. Who was that individual? Where did that individual go after his buddy got caught? He ran off to New Jersey. Connection to what? That letter that was found in the car. That's also corroborating evidence that he was there at the crime scene and committing this crime. Altogether, also testimony in here, you got that shell casing that was tested against the gun. It did not come back to that gun. You heard about the one shot. Several witnesses testified to that. You got shows that the front seat passenger in the white shirt, watch the video, it's a white shirt. Watch the El Paltacino video, it's a white shirt. El Paltacino video as they pull up, or when they have pulled up already. That's Tamor McIntyre walking around a car. That's that is Tamor McIntyre in that white shirt that got out of that front seat passenger. And that's the individual that shot Mark Salvador. If you look at the timestamps on these videos, also at the beginning of each of the videos, you'll notice that the times 5:19 was in the Chick-fil-A parking lot. When the initial video of El Patrocino, it's registering at 5:20. Maybe a minute from one location to the other, if not seconds. So that Chinese fire drill that defense counsel was mentioning, probably a pretty fast one, I guess. El Patrocino, the black key is there. This shows the 4 individuals in that vehicle. You have been told who those are. The white shirt of Tamor. You watch that video image, and that's Tamor's physical body. He is a 16 and a half, almost 17-year-old individual, slight build. He's growing up. He's growing into Tamor McIntyre. The wallet is found of Mark's, establishes robbery at this location. You watch that video, you watch Jalen Bell, 6'4" of them, 240 pounds of him, putting on a backpack. You see it as he goes out and he's walking with Tamor McIntyre. You see him take the backpack off and then rearrange, and they walk off into the night, or the day rather. More corroborating evidence, a lot of corroborating evidence in that black Kia. How many of you, everybody in this room, where's your cell phone right now? You know exactly where your cell phone is. Tamor's was in the glove compartment of the black Kia that was in the murder investigation. That's where his cell phone was. You know where your cell phone, everybody knows where your cell phone is. Tamor McIntyre left it in a car because he was running off into the day to get away from that vehicle from a murder. You also heard my co-counsel, Ms. Galloway, talk about the phone records. That's in evidence. Tamor's phone records compared to Joanna's phone records. There's intermediate phone numbers mismatched several times. Jeremiah's fingerprints are found in that car. Sergeant Wars established Jeremiah was in that car through his investigation. He was interviewed by Sergeant Wars. His rendition, his interview is consistent with all the evidence that was collected. Clothes of Tamor, Jalen, and Joanna were found in that car. The slides, the jerseys all match up with Tamor McIntyre being in that vehicle. Letter belonging to Tamor McIntyre is in that vehicle. Also, the photo in the center console of Tamor and Joanna. If you look at this, that photo on the left-hand side is that photograph that's laying in the console in the middle. Shows her in a jersey of that Chicago, or some type of football jersey with Tamor, where you can see his white high tops, Nike. The wallet to your right is Mark Salvador's, testified by Miss Salvador, his mother. That's evidence of a robbery. That's not the scene of where it happened, but it happened at Chick-fil-A or at that intersection. It was ongoing the whole time. If somebody's robbing you, they're taking it, and you're trying to stop them from taking some of your objects, you can try to stop him. He tried. Corroborating evidence, all 4 of these witnesses testified a young black male in that front seat with a gun. Ernest Reyes testifies that Mark screams, "Help, help, give me my things, give me my things." Evidence of a robbery. Witnesses, Anna Delgado, Gabriel Baez, Jasmine Cruz, which we've already spoken about, describes that scene when she was there. Lucy Salvador, the mother of Mark, establishes Mark was excited about a photo shoot.
5 minutes.
911 callers, you've heard from all of them. Little inconsistencies, I agree. Defense counsel is very able to determine, that, some Hispanic, a white person or something like that. But, the fact is, if you look at the consistent things, front seat shooter, a gun, a black car, and guy on the hood. Consistent with everybody else's testimony. That's one word you're going to hear over and over is consistent, consistent, consistent. Tamor runs off to New Jersey. He's found up there, and then he's brought back to Tarrant County. Then he's brought back to Bexar County to face these charges. tending to connect the defendant with the offense. Everything that I just went over, but reiterated. Fingerprints of the accomplice, Jalen Bell. Jail calls established McIntyre and Bell's friendship. Video image of El Potosino matches Tamor's physical body. The blue iPhone belonging to Tamor McIntyre. That phone. Tamor's phone records are Joanna's phone records. Testimony of Mark's phone number on Joanna's phone records. Jeremiah interview consistent with all this evidence. Clothes of Tamor and Jalen and Joanna in that car. Photo in the center console of Joanna and Tamor. And then the letter belonging to Tamor. This is all corroborating evidence that you can use in your determination of an accomplice, witness, testimony, and the truthful of that. Because the fact is, there's that letter addressed to Tamor. The same place where his phone is found in that vehicle. Remember, corroborating evidence just needs to tend to connect and the defendant to this offense. Tend. Doesn't have to be beyond a reasonable doubt. But then you add all this evidence together, all of it together, and you get a view of a credible evidence together, and you get consistent evidence confirmed by overlapping evidence, video, testimony, and all other collected evidence equals beyond a reasonable doubt of guilty. Easily. Briefly, if capital murder, that's what we're asking for, the guilty. And just to briefly, since it was brought up, if this is self-defense, what are we looking at then? What type of society? If robbing a victim and then say...
Object, that's improper argument.
I'm asking you to enforce the law here, because if you're robbing somebody and you take something from somebody and then you argue that the defendant or the victim doesn't have a right to get it back, not here. The defendant provoked the victim by taking his things, his passion.
2 minutes.
Mark Anthony Salvador died that day. Justice for Anthony Salvador. He had a passion of photography. His mother testified to that. That's evidence. He had that camera that you see in this photo that was never found, might add. I agree with counsel. Never found. Why? Because of that man and his buddy. Make him take responsibility. You go to the page in this charge and go to capital murder, and then you flip to the back to the verdict form and say guilty of capital murder, because we have proven every single element beyond a reasonable doubt, especially that this individual, Mark Anthony Salvador, deserves justice. After so long, so many years later, he deserves justice. And just because it's old doesn't mean that it's bad evidence, but he deserves it. His family deserves it. Heck, we all deserve that. We don't want a society like this.
Objection, improper argument.
We want law enforcement, and that's what I'm asking for. Hold Tamor McIntyre, TK-47, accountable, and come back with a verdict of guilty on capital murder. Thank you, ladies and gentlemen.
A jury has been deliberating for more than 5 hours now in the capital murder trial of Texas rapper Tamor McIntyre. He's accused in the murder and robbery of photographer Mark Saldivar. Erica Hernandez is at the Justice Center awaiting a verdict. And Erica, are there any lesser charges that the jury could consider in this case?
Yeah, Myra, before I answer that question, we're being told right now that the judge is probably going to release the jury for the day and have them come back on Monday to resume testimony. So there are 2 lesser charges they can consider, which is murder and manslaughter. So they've been at it for more than 5 hours, so it seems like they're having trouble coming up with that decision. So yes, as of right now, they are going to probably come back on Monday to resume those deliberations. But as far as closing arguments earlier today, this is what the state had to say.
Make him take responsibility. You go to the page in this charge and go to capital murder, and then you flip to the back to the verdict form and say guilty of capital murder, because we have proven every single element beyond a reasonable doubt, especially that this individual, Mark Anthony Salvador, deserves justice after.
Now, while the state is hoping for that guilty verdict on capital murder, the defense is saying the state didn't do enough and that McIntyre should be found not guilty.
Taylor McIntyre is not guilty. He's not guilty of capital murder. He's not guilty of murder. He's not guilty of manslaughter. And the reason for that is very simple. If you're going to charge someone with that kind of an offense, if you're going to take their liberty away from them, then you have to do it right. You have to do the work. And as this case clearly demonstrates, the work wasn't done.
Now, if he is found guilty of capital murder, he would automatically be sentenced to life in prison. If he's found guilty of any of those lesser charges, we would have to go into a punishment phase. But as of right now, we don't know what direction the jury is leaning. But as far as we know, it looks like they're going to have to come back on Monday to continue those deliberations. Live at the Interviews Justice Center, Erica Hernandez, KSAT 12 News.
Well, those were the events in Judge Boyd's court this past week. But now I'm going to take you back to January 4th, 2024. And we're going to meet a new judge to the channel, Judge Krause, who is an appellate judge. And she has an appeals in front of her that reminds me a lot of Abel Estrada. Haven't seen the Abel Estrada update? You should. It all starts right now.
Okay, so I'm ready to take up the matter of the Natasha Ballard versus D23 LLC, which is an appeal from a dispossessory order in magistrate court. Ms. Ballard, as I mentioned, I have reviewed the petition that you filed with the affidavit that was accompanied it. And so did you wish to make any oral presentation here at the hearing, or do you want me to rely on what you have submitted in your briefs, which again is fine. You may do whichever you wish.
Sure. So from my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity. I'm requesting that this motion under the titles, under the Rule 60B, that, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavit that I submitted. And bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interests and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put in an affidavit to ask for rent. So, and there's no contract, but I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Okay. I am going to call on Ms. Akpati for her response right now, Ms. Ballard. And then, as I said, because you're the movement on this matter, I'm going to call on you and let you have a chance to respond. Okay. Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action, and the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. Excuse me, by the defendant D23, the filing fee. Ms. Ballard, do you have any documentation? I'm looking at the file and I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money order.
Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th. That awarded a money judgment in the amount of $459.40 to Ms. Akpati's client, D23, and then also ordered that any rent amount in the amount of $998.11 had to be paid on the 5th of each month, beginning, let's see, with January the 5th. But that would have required a prior payment in December. And there's no, respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some, issue with it being credited to the wrong file, or something like that. But absent any such documentation, there's no evidence that the required payment has been made either into the magistrate court or into the superior court file. And absent that payment being made, the order that was entered very clearly says that if tenant appeals the judgment and wishes to remain in possession of the property, those payments must be made. And so that would typically mean that the dispossessory order would be issued in stanter, and D23 LLC would be entitled to possession of the property in stanter, which, you know, would mean immediately. Do you have any additional documentation that you could perhaps email to Mr. Freehoff and copy Ms. Akpati on so that I could see it and then follow up with the clerk regarding what happened to a payment that you made?
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Well, actually,
so I have to feel bad.
Actually, that's not correct. So the file indicates,
absolutely.
Ms. Ballard, the file indicates that you submitted an affidavit of poverty, and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I
Yeah.
tendered a payment in the magistrate court.
Right.
Otherwise,
I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
according to law, I tendered the payment, and I don't know if there's some type of mix up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able, they even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly. I'm back.
Excellent. Very good timing. Ms. Ballard, were you able to locate some materials regarding that matter?
Yes, so let me just turn on my camera real quick. One moment. Okay, so
yes, ma'am.
I filed a notice of tender payment into the courts, and yeah, so to settle this account, I did file a tender payment to the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed. And if you like, I mean,
Ms. Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284322 case number?
It's 23 ED 284322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a second.
Thank you.
Yes, Mr. Freehoff.
Judge, I just wanted to, I'll come talk to you.
Okay. Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that I think that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay. That was filed. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court. and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. The Ms. Ballard has to comply with the order of the court before filing this appeal.
Okay. Ms. Ballard, I understand. I find, first of all, thank you for helping me understand what it was you filed, because originally when you were saying a money order or something like that, I was looking and I was not finding. And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, you know, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States, then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
what species?
Excuse me, Ms. Ballard, I'm speaking, and in a moment I'll let you respond if you would like, but you have to let me finish speaking.
Thank you.
So as I was saying, the motion, I think, is to dismiss the appeal of the dispossessory and to issue a dispossessory affidavit in stanter, which would seem to be appropriate here because there's been no payment made. And in the absence of a payment, there can be no appeal. And that is the position that D23 is taking. Would you like to respond to that before I rule, Ms. Ballard?
Yes. So, I mean, on the order, it did not specify how to pay. What species of payment is on there to pay. It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States, which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So, in all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehoff, please mute Ms.
I need
Ballard
to finish what I have to say.
Mr. Freehoff, please mute Ms. Ballard if she's going to continue to speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not trying to be respectful. You're
Ms. Ballard,
me and not properly.
you are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a ruling over something that you don't know.
I'm sorry, Ms. Ballard.
You cannot make a ruling over something you can't know. You saying you don't know is an unacceptable response, respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law that says that what you submitted is legal, Ms. Ballard.
Is this a court of law? It is unacceptable for you.
This matter is adjourned. Ms. Ballard, you may pursue whatever appellate remedies you would like to pursue.
And we're going to have another hearing in person because you guys are very disrespectful.
Thank you, Honor.
Thank you, Ms.
Yep. That just happened. You saw that, right? So that's what happens when a soft sit thinks they have all their stuff together and actually gets into an appeals hearing without doing the things they were ordered to do by the judge in the lower court. I just thought that was real interesting, and I have a feeling that Mr. Abel Estrada has a hearing much like that one in his very near future. If it even gets to that point with that guy. I don't even think it'll get to the point with that guy. But you guys can let me know what you think. I've had a great time this afternoon. It's been a great show. These were some very interesting cases. And just to let you know, I have another really interesting case with Judge Ricky coming out later on today. So make sure you're subscribed. Make sure you have those notifications turned on. Keep an eye out for real interesting Ricky. And come by every weeknight around 9 p.m. Eastern Time, 8 p.m. Central Time. We'll all be hanging out and chatting while watching some Judge Fleischer. Or somebody. Ladies and gentlemen, I'm your Lone Wolf Oozle. I'm your host for this here weekend get-together, and your curator for Court Gallery, Court Repository, and I'm here. Thank you so much for being here with me. I'll see you all next time. Won't be long. Y'all have a great weekend. We'll talk to you as soon as court gets back in session. See you Monday.